Disability Rights Disability Rights New York, but I am also on the governing council of the New York State Special Education Task Force, which has brought you this Lunch and Learn series. And this is our concluding event of that series. For those of you who have participated in other ones, we appreciate your attendance and spreading the word. We found these to be very successful, and all of them have been recorded and are available on the Special Education Task Force YouTube channel. And we can provide a link to that later. If you're not familiar with the New York State Special Education Task Force, we are a group that came together almost 20 years ago in the Capital Region for the purpose of sharing information on issues impacting students with disabilities. And what makes the task force very unique is that it's always a collaboration between all of the stakeholders involved in special education. So that includes families and students and school professionals and service providers. We feel when everyone is sharing information and learning information together, there can be a really healthy exchange that can promote communication, and that always promotes better outcomes for students with disabilities. There is more information on the Special Education Task Force website. I will tell you that we are in the process of transferring and creating a new website for the task force that's going to have tons of resources, and we're really excited about it. Everyone will be notified when that happens. We're hoping that that will be completed by the fall. Before I get into our presentation today, I just have some housekeeping matters. Closed captioning is available in English and in Spanish, and those links have been provided to you in the chat. We are recording this presentation. Feel free to shut your camera off, and if you wish to hide your name, you can, change your name or identity in your own settings on Zoom. We are also going to be reserving about a half hour of today's session, the last half hour, for questions. You can go ahead and put questions to the hosts. Questions aren't really going in the chat, they're going to the hosts. And then we will make sure that Jessica addresses those questions as time allows at the conclusion of the presentation. So probably around 1 o'clock. We are recording this session, and it will be available on the YouTube channel probably within a couple weeks. In the meantime, we ask that you stay muted, and we will be posting a link to an evaluation at the end. One of the things that we ask on the evaluation is whether there are any topics you would like to hear about in the future. And we will be planning the 2025 Lunch and Learn series. And so if you have any suggestions on what would be helpful to you or what you want to learn more about, we really encourage you to add that to the evaluation. The evaluations are very helpful to us in planning and delivering high quality information that people really are looking for. So with that said, I'm going to pass it over to my colleague actually here at Disability Rights New York, Jessica Richwalter. Jessica works in our program that helps people with a wide variety of disabilities, but specifically and more particularly people who fall more into the 504 category than IDD, intellectual or developmental disabilities. But most importantly, she's handled a wide variety of issues involving 504 and IDEA to a certain extent, and has been very successful in bringing schools and families together in a way that benefits the student. And therefore, we thought she would be an excellent choice for today's presentation. And I am sure you're going to enjoy it and learn a lot. So with that, I will pass it off to you, Jess.
Thank you so much, Julie. Let me just take a moment here to share the presentation and make sure that that is all set up for us to begin. And so as Julie said, my name is Jessica or Jess Richwalder. I'm a senior attorney here at Disability Rights New York. I've been here for almost 10 years, working with folks with all sorts of disabilities, and along the way worked with a lot of students and their families with disabilities in the education realm. And so today we're going to talk about 504 plans, IEPs, and beyond. And the beyond will really encompass the less traditional or less thought about areas of federal law primarily that can offer protections and accommodations for students with disabilities. So what we're talking about today is I will mention the IDEA and IEPs, but primarily we want to provide an overview and an introduction to the other laws that might allow students with disabilities to access accommodations that they need to have the best experience and access in their school. So with that, we'll start with the 3 federal laws that we want you to be familiar with in this context. The first of which you may have heard about in a non-education setting, and that is the Americans with Disabilities Act, the ADA. And so this is a broad federal civil rights law that prohibits discrimination against individuals with disabilities by state and local government entities. So public school districts would fall into that. The next you may have heard of in the context of a 504 plan. The 504 comes from Section 504 of the Rehabilitation Act, which is another federal anti-discrimination law. And that law, very similar to the ADA, but a little bit different, protects individuals with disability from discrimination in any programs or activities that receive federal financial assistance. So again, schools will fall into this, and we'll refer to that as Section 504 or 504. And then the other federal law is the one that many of you are probably already familiar with, and that's the Individuals with Disabilities Education Act, the IDEA. That's where IEPs come from. And that federal law mandates that schools make a free, appropriate public education available to all students with disabilities. And so public schools must comply with all 3 of these laws. And while sometimes compliance with one will result in compliance with all, as we'll discuss today, there are some situations where a school may be complying with the IDEA, but has to take other steps in order to comply with the ADA or Section 504. And it's worth noting at the beginning of this discussion, again, that Section 504 and the ADA are broad non-discrimination laws. They don't just apply to education, and they don't just apply to elementary, middle school, high school education. These are the laws that will apply to people with disabilities if they go to college, if they enter the workforce, in housing, healthcare, employment, and beyond that. So some of the concepts that we talk about today will be widely applicable for the rest of a student with a disability, the rest of their life as they leave their high school and public school environment and go beyond that. So to begin, we're going to go over a couple of key points and some general ideas, and then we'll move into more specifics about how to receive accommodations under these laws, what those requests look like, what those processes are. We'll go over some examples, and then also talk about what to do if you feel that maybe a school district isn't meeting their responsibilities under these laws. So we like to see the 3 of these laws all work together and with other state and federal laws to give the most access possible to a student with a disability. As a general rule, whichever law or part of a law provides the most protections and the most accommodations will be the law that is the controlling one. You won't find a situation where a school district can say, well, the IDEA only requires XYZ, so we don't have to do what the ADA requires. If the ADA is requiring more, it would be the ADA or Section 504 on top of what's required by the IDEA in many situations. The ADA and Section 504 will also apply to all programs, activities, and services of a public school district, not just educational programming. And the ADA and Section 504 will also provide protections for students' parents or their guardians if those individuals have disabilities, because as I said, these are not just education statutes, they're broad statutes, laws that protect people with disabilities. So if there are family members of students who have disabilities themselves, then they may be able to receive accommodations from school districts as well. Both the ADA and Section 504 have a very similar definition of what a disability is, and it's a really broad definition. So it's any physical or mental impairment that substantially limits one or more major life activities. And so major life activities is a really broad term. It can be eating, walking, speaking, hearing, breathing, any functions of your major organ systems. All of those are going to be major life activities. And so if there is a condition that is impacting one of those, then most likely that person would have a disability under the ADA or Section 504. And unlike with the IDEA, the disability does not have to impact a student's ability to learn in order for them to have access to accommodations under this. It just has to be a disability. And so in some instances, the ADA and Section 504 will cover students who do not qualify for an IEP under the IDEA, but they do qualify for other accommodations under Section 504 and the ADA. So again, there's no requirement that the disability be education related. For example, a common example is diabetes. Diabetes doesn't prevent a student from learning, but that student will require medical and other assistance outside of what a student without a disability would require during the school day. And so while that student may not qualify for services under the IDEA, they would qualify for those extra medical and nursing services under the ADA and Section 504. So under Section 504, as I just said, a student who does not qualify for an IEP can still receive disability-related services in what is typically called a 504 plan. This document generally looks very similar to an IEP, and that's just because it's easiest for most school districts to use the same formatting, but it is governed and controlled by Section 504 and not the IDEA. And so if you're familiar with the IDEA, you'll know that there are many procedural requirements, specific timelines for things, specific ways that the school district needs to communicate with parents and guardians, specific ways that documents need to look, and those rules would not apply to a 504 plan. And so a lot of what a 504 plan is just what's reasonable, and that's a very broad term, and we very much understand that, but there's a lot more flexibility with a 504 plan. So we also like to note that if a student does qualify for an IEP, but there are additional services that would be provided under Section 504 or the ADA, we often see that school districts will provide those in an addendum or an attachment to the student's IEP, rather than drafting a separate 504 plan. And that's perfectly okay. Some school districts like to separate them, some like to keep them together for convenience. Either way, the same protections are going to be available to the student. A key important part of thinking about what's available under Section 504 versus what's available under the IDEA is the differences in FAPE. And so FAPE is the free appropriate public education. And so under Section 504, general or special education services must be given by any appropriate means. And so this is a negative prohibition against discrimination, meaning that the standard is that a school district cannot discriminate against a student with a disability. And when you're determining whether a school district has provided FAPE under Section 504, you are comparing the services that are received by the student with a disability and how their needs are met to how the needs of a non-disabled student is met. So we want the student with a disability to have the same level of access as a student without a disability. On the other hand, under the IDEA, this is an affirmative duty to provide appropriate public education. And so this is an individual standard where we're not comparing the students to students without disabilities. We're just asking if that student's services enable them to make progress in light of their individual circumstances. So you'll see there that we're just talking about the one student and their IEP, while under 504, we're comparing that student to students without disabilities. The ADA does not have a specific FAPE requirement, so there is no separate definition there. So in order to receive FAPE under Section 504 and for students to equally access their education under the ADA, a student may need to request what is called a reasonable accommodation. This can also be called a reasonable modification. The two terms are generally interchangeable. A school district cannot operate on assumptions or generalizations about a student with a disability, so they can't assign the same accommodations to every student who has the same disability. And that is because one of the primary goals of the ADA in Section 504 is to protect individuals with disabilities from discrimination that is based on those types of prejudices, and not to exclude students solely on the basis of their disability. And so we often see this come up with school districts that have a blanket policy about something. You'll hear them say, well, this is what we do for everyone, or we don't do that for anyone. And if the school has refused to make any exceptions to a policy, even on the basis of a disability, it's possible that the school is violating the ADA and Section 504 by refusing to make a reasonable accommodation. And we will go over some examples of what that can look like. So what is a reasonable accommodation? A reasonable accommodation is an adjustment to what the standard policy, practice, rule, procedure, how things are done that would allow a person with a disability to have access to the services, programs, activities, access to the school system that would otherwise not be accessible because of their disability. It is a broad civil rights law, as I said before. So when thinking about what accommodations changes are needed, it doesn't necessarily have to be specifically related to their classroom learning or to their ability to learn. It's just about making sure that they can do the things that students without disabilities can do. So some examples: students with disabilities can receive academic adjustments, changes to how they receive their academic programming, auxiliary aids, which are usually physical pieces of equipment that can be provided, services, and other reasonable accommodations or changes to policies. So again, this includes non-academic programming like extracurriculars, and it only has to be directly related to their disability and be required to access the school service. Again, it doesn't necessarily have to be education related. And so, like I said, you can be creative and individual when thinking about what types of accommodations you would want to request. And generally, a school district or another public entity would be required to provide those accommodations unless there is one of these three situations. So one, if it's an undue burden, which would typically be a financial limitation, and this is rarely a legitimate excuse under Title II. A fundamental alteration, which is a change that is so significant that it would alter essentially the nature of the services that the school is providing, or a direct threat, and that's fairly self-explanatory, that it would potentially cause harm to other students or other members of the school community. You may find in discussing reasonable accommodations with school districts, with CSE teams, with potentially a school district's attorney, that those attorneys and individuals may not be very familiar with the requirements of the ADA and Section 504 because they're not used as commonly in the education environment. And so you may receive pushback from the school stating, well, we're meeting the IDEA, so what is this? And that's why it's important to emphasize that this is a different and separate requirement that can be on top of the requirements under the IDEA. So unlike with the IDEA, where the school has an affirmative responsibility to identify that student with the disability, offer those services in the IEP, the responsibility under the ADA and Section 504 is on the individual with the disability or their parent or guardian to make that request. So the school district is required to evaluate the students, if they're suspected of having a disability, but it's less common when the disability is a medical condition that a teacher or other staff member might not be aware of, or is perhaps an invisible disability that, again, might not directly impact a student's ability to learn in the classroom. So it might not be something that a school would suspect a student of having. So when you're making a request, this is typically a letter, and you would want the letter to state the student's disability, the accommodation specifically that you are requesting, explain the relationship between the disability and the accommodation, so why the disability means that the student needs that accommodation. And then you can include an offer for medical support to be provided upon request of the school district. Under the ADA and Section 504, generally, a school district would be entitled to documentation, essentially proving the disability, a medical professional stating that the student does have whatever that condition is and how that condition necessitates the accommodation requested. One of the primary exceptions to this is if the disability and the accommodation requested are obviously connected. And the primary example of that is if a student is a wheelchair user and requests a ramp to access something in the school, then no medical documentation is required in order for the school district to see that that is a necessary accommodation. And the school, hopefully, once they receive that accommodation request, they will respond. And sometimes they won't respond to your request and you'll need to follow up, but we hope that they do respond, and they are required to respond in some way. And so when evaluating the request that has been made, a school should consider the following: whether the modification is reasonable, so whether it's attainable, whether it can generally be implemented, whether the modification is necessary to enable the student to participate. Again, we're looking at whether this accommodation or modification would allow the student with the disability to have access to something related to the school that students without disabilities have access to. And then whether it would fundamentally alter the nature of the school or cause an undue burden. So those are the legal reasons that a school could say no, whether it would change something so significantly that it would no longer be what it was before the accommodation was made, or whether it truly is prohibitively expensive to provide the requested accommodation. So in talking a little bit more about those legal reasons that a school can refuse to provide an accommodation, for a fundamental alteration, it is important to remember, and often most relevant, that a school is not required to lower its academic or other requirements for admission, retention, participation, or graduation. Those would be fundamental alterations of the school's programming. And a school is not required to implement an accommodation that would be significantly expensive or difficult to do. And the school is responsible for explaining which one of those, or direct threat, that is the basis for them saying no to the accommodation. So they have to provide the evidence, the support for that in order to deny the request. We hope that the school provides the response in writing. They don't always do that, but we would always recommend that people request the response be in writing. And if they're denying the accommodation, the school is responsible for explaining why the accommodation was denied and citing the legal reason and the facts and analysis that went into making that determination. And then we would also want to see them offer alternative accommodations to what was specifically requested. And so this is a really important thing to keep in mind under Section 504 and the ADA, is that a person with a disability in most circumstances is not necessarily entitled to the specific accommodation that they want, the specific thing that they asked for. They're just entitled to an accommodation that is reasonable and effective. So if there are two equally effective accommodations, then generally in most circumstances, a school district is entitled to choose the accommodation that they would like to provide to the student. One of the primary exceptions to that, which will apply to some folks, and so we like to mention it, is effective communication. And so this is an ADA specific requirement that states that schools must provide students with disabilities and their parents and guardians with communication that is as effective as communication with non-disabled students. So this claim can exist even if the school district has met all of its requirements under the IDEA, as I mentioned before. And in this specific instance, the law is very strongly in favor of the individual with the disability and what they need to be able to receive communication. So receive lectures from their teachers and information throughout the school day, whether in the classroom, in extracurriculars, in other programming. And so you'll see that the language here labeled 1, 2, and 3, that's language that's actually pulled right from the language of the ADA. And I include that because it is so specific. A public entity shall take appropriate steps to ensure communication with members of the public with disabilities is as effective as communications with others. So you'll see use of the word shall there. It is an absolute necessity under this section of the ADA that the steps be taken, and that in order to provide effective communication, they shall furnish the auxiliary aids and services. Often that is a sign language interpreter, captioning services, other services that the student with the disability needs to be able to communicate. And then this is where there is an exception to what I talked about on the previous slide of the school district being able to decide which accommodation it wants to provide, assuming that all other things are equal. Under the effective communication mandate, the individual with the disability gets primary consideration of what they've requested. And so in this instance, for example, if an individual has a hearing disability and they've requested a sign language interpreter and the school district wants to offer captioning services, the school district would have to provide the sign language interpreter, as that is the request of the individual with the disability. Extracurriculars. So as I have mentioned, the mandates of Section 504 and the ADA do not only apply to the academic aspects of the school day, they would also apply to extracurriculars. And there are mandates under the IDEA that sometimes apply to extracurriculars, and sometimes sports and clubs and other things are included in students' IEPs. So this isn't to say that they're never providing services or receiving services in extracurriculars, but again, Section 504 and the ADA might provide additional services and accommodations. So just like with any other accommodation, districts are required to conduct an individualized inquiry. So they're required to look at the individual with the disability, that specific student, and the specific needs that they have to participate in whatever the extracurricular is, to determine whether the reasonable modifications or the services they need would allow them an equal opportunity to participate. School districts are not required to create a separate or different activity for students with disabilities only, or to modify the skill and ability requirements in order to allow students to participate, particularly in competitive activities. If a district fails to provide those supplementary services necessary for a student with a disability to participate, that may be considered a denial of FAPE, and that could be a denial of FAPE under the IDEA as well, but particularly under Section 504. And so I know I've given a lot of information in these past slides, and so I want to move into some examples here, and these examples will provide a short description of a situation, and then I'll give everybody just a minute to think about it and to think about what we have gone over so far, and then I'll bring up the answer to the question that the examples pose and talk a little bit about that. And I hope that these provide some examples, I guess, of what I've been talking about to illustrate the concepts that we've gone over. So the first example is about Barrett. Barrett is a 7th grader who has hearing loss and uses cochlear implants. Even with his cochlear implants, Barrett cannot hear everything and uses lip reading and educated guesses through observation to fill in the gaps of speech that he does not hear. Barrett has an IEP that provides for an FM amplification system, copies of written notes, and obstruction-free seating. In addition to these things, Barrett requested communication access real-time translation. This is CART, which is a real-time transcription service that displays words on a screen as they are spoken. Because Barrett does very well in school, his IEP team denied his request. And so the question here is, does Barrett have a right to CART services? I'll give everyone just a moment to look at that and think about it. The answer here is yes, the Barrett does have a right to CART services. And so while he is doing well in school, and therefore the school is probably meeting its obligations to provide a free and appropriate public education under the IDEA, even without CART, the obligation that I talked about with effective communication under the ADA is not being met. And to look at that, we think about the fact that just because Barrett can compensate doesn't mean that he should have to. He shouldn't have to take those extra steps that students without disabilities don't have to take in order to communicate in the school environment. And so if there is an accommodation, which there is, that will put him on that equal footing, then the school is obligated to provide it under the ADA. Our next example is about Jane. Jane has a heart defect, which requires frequent medical intervention and multiple surgeries a year. Jane's medical needs result in extensive absences, which has caused her to fall behind in class. When Jane learns that she is failing her classes, she requests tutoring as a reasonable accommodation to assist her in catching up with her coursework, but the school district denies the request and removes her from her current diploma track. So the question here is, was Jane's accommodation request reasonable? And the answer here is likely yes. So under the ADA, as well as Section 504 and the IDEA, a school district is required to address a student's individual needs related to their education, even if those needs stem from a disability that does not impact the student's ability to learn. So Jane's disability has caused her to have extensive absences from school, which has resulted in her falling behind in her classes. It hasn't impacted her ability to actually learn the material. But had Jane requested to pass the classes without doing coursework or advance in her diploma track without passing the classes, the request may have been a fundamental alteration. So as we talked about, schools are not required to change their graduation requirements or other things like that, but they may be required to provide extra services to students so that they can access those diploma tracks or those courses. Our next example is Jacob. Jacob is a 1st grader with type 1 diabetes who needs help to manage his medical needs. Jacob also receives speech services while at school. Jacob has an IEP for his speech services with a medical accommodation addendum to address his diabetic needs. When Jacob's school reopened in the fall, this example is from a period of COVID-19. I was going to change it, but I think it helps illustrate this point, so I left it. General education students attended class remotely for 3 days a week, and all special education students attended school 5 days a week in person. Because Jacob has an IEP, he was categorized with the special education students. However, Jacob's type 1 diabetes puts him at high risk of complications should he contract COVID-19, and his speech services can be effectively delivered via Zoom. So Jacob's parents requested that he be permitted to attend on the general education schedule of remote classes 3 days a week. So should Jacob's school district grant his reasonable accommodation request? And the answer is yes. A blanket decision that all special education students must attend in person may be discriminatory as it does not account for whether individual students' needs can be met remotely. And so the school may have reasons why it wants special education students to attend in person, whether there are certain services that can be better provided in person, or the needs of those students can be better met in person. But in Jacob's particular circumstances, his special education services, those speech services, can be effectively provided via Zoom, and he has a different disability, type 1 diabetes, that requires a different accommodation, which is attending classes remotely when allowed. And so you'll see here, again, that this is an example of a student that has an IEP with a medical addendum for his diabetic needs. So that medical addendum would be under Section 504 and the ADA, and that's providing additional services, and in this case, additional accommodations that might not necessarily be provided under the IDEA with his IEP. Our next example is Anna, who has a traumatic brain injury that causes tremors in her hands, arms, and torso. Anna is a member of her school's golf team, but she has trouble putting because of her disability. She requests that the holes be widened from 3 inches to 6 inches in diameter in order to assist her. And should this accommodation be granted? And in this circumstance, we would say no. This is a change to an essential aspect of the game. The size of the hole in golf is fundamental to the game. And so changing it would be an example of a fundamental alteration. It would change the essential aspect of the sport. In this example, we have Jaden. Jaden has a birth defect, which results in him only having one hand. He is a member of his school's swim team and requested a modification to the rules that swimmers must finish a race with a 2-handed touch. Should this modification be made? And in this circumstance, we would say likely yes. This modification would not likely affect an essential aspect of the race or provide an unfair advantage, and so it would not constitute a fundamental alteration. I hope those examples were helpful in illustrating some of the concepts that we've gone over so far, and letting you kind of see where the line is between reasonable and not reasonable and how that might apply in the school setting. Next, we're going to talk about what happens if the school district denies a reasonable accommodation request that we believe they should have granted. So one option is litigation. So that means taking the claim to court under the ADA or Section 504. That would be in federal court because those are federal laws. And so you would make a claim of disability discrimination. Another option is an administrative complaint. And so instead of filing a complaint in court, you would file a complaint directly with the U.S. Department of Education or the U.S. Department of Justice. And both of those entities enforce the ADA's non-discrimination mandate. And so in education claims where there is an ADA claim and a 504 claim, there may also be IDEA claims for those students who qualify under both of those laws. And so when courts are evaluating claims under the IDEA and Title II of the ADA, they have to look at each of those claims separately under the relevant law and the regulatory framework. Like I said before, way back at the beginning, the IDEA has a lot of procedural requirements and specific ways that things need to progress in order for claims to be made. And the ADA and Section 504 are not subject to those same procedural requirements. And so success or failure of an IDEA claim does not necessarily dictate or result in the same success or failure of an ADA or a 504 claim. An important distinction in seeking remedies under Section 504 in the ADA is, unlike the IDEA, Section 504 and the ADA do not always require exhaustion of administrative remedies prior to going to court. And so, as many of you may know, under the IDEA, you are required to go through the due process procedures and administrative hearing procedures before being allowed to file a lawsuit in court about a violation of the IDEA. That is not always required under Section 504 and the ADA. It is sometimes required, and it's a bit complicated when. I'll go over it briefly, but if you don't understand, that's perfectly fine. There are many lawyers who spend a lot of time trying to understand, and we still wonder if we've quite got it. So generally, the premise is that exhaustion is not required where the substance of the claim brought under another law, so the ADA or Section 504, is not about a denial of FAPE. And so what we're looking at when we're determining whether you're required to go through the due process procedures is, could the plaintiff, the person, the student, have brought the same claim if the issue that's at the basis of the claim occurred at a public facility that was not a school, say maybe a public library? And another easy question to kind of help us understand is, could an adult at the school have made the same claim? And so an example of this that we like to use, and that is actually one of the basis of one of the controlling lawsuits and cases in this, is about a service animal. So if a student who uses a service animal under the ADA is denied access for their service animal to their school district, they would not necessarily be required to exhaust administrative remedies under the IDEA, because the claim is not about FAPE, it's about access under the ADAs, meaning in the examples I provided, that the student, if they went to a public library and were denied access for their service dog, they would have the same claim that they have against the school district. And an adult who was coming to the school, and if they had a service animal and they were denied access, would have the same complaint. So that's an example of a claim that is against the school district for violating, in that instance, the ADA and the ADA's protection of service animals, but is not about a student's access to a free, appropriate public education under the IDEA. And then a few other points that we like to just point out here about remedies is that money damages are sometimes available for a denial of Section 504 FAPE, as well as for general discrimination claims, though recently emotional distress damages were taken off the table, and so that is much more is fairly narrow now. A showing of bad faith or gross misconduct may be required, and so those are legal terms that essentially mean that the school district has to have done something pretty bad and really meant it in order to be able to bring a lawsuit. And in a lot of situations, the courts will defer to the professional judgment of educators, physicians, the students' doctors, psychologists, the folks doing evaluations for special education and other services in determining whether an accommodation actually meets the student's need. And so there's often a need for experts and other folks to weigh in on these types of claims. We also like to mention retaliation, because we know folks are hesitant to push back against school districts and other entities for fear of things becoming worse or services being taken away. And so retaliation is illegal under both Section 504 and the ADA. And so retaliation is really any negative result that comes from a student or their parent or guardian trying to seek accommodations, whether it's requesting new or updated accommodations, or really just exploring their rights under Section 504 and the ADA. And requesting an accommodation itself is a protected activity. So if there is a negative result of that request that's made by the student or their parents, then that is retaliation. And that in order to show that claim, you would need to show that a reasonable person would have found that negative result to be a negative thing, that a reasonable person would think that whatever the school district did in response that you think is retaliation was something that would either deter someone from enforcing their rights in the future, or just that generally a reasonable person would agree with you that that was not an appropriate response. And lastly, the ADA prohibits interference, coercion, or intimidation for against a student with a disability or their parent or guardian for engaging in those protected activities, discussing accommodations, requesting accommodations, asking for accommodations. And so interference would be preventing a student from requesting an accommodation, the school district refusing to accept a student's written request for accommodation, refusing to discuss it. Coercion would be pressuring an individual to forego an accommodation to which they're entitled. For example, a school district could offer to provide a different service that maybe a student or their family had wanted in the past, if that student's willing to let go of their request for a different accommodation. Or even intimidation, threatening an individual by indicating that there may be retaliation, saying that maybe a student would be declassified or would have other accommodations taken away or wouldn't have access to classes, extracurriculars, things like that, if they were to continue with their request. And a statement that no exceptions will be made, which is something we've talked about a few times throughout this presentation, may be illegal, as it can make a student feel that their right to invoke those ADA protections and to seek those accommodations has been limited. And so that is the end of the information that I have to provide to everyone. I know that we probably have questions, and so we're happy to take those now. I will close out this screen so that I can actually see the questions now.
Thank you, Jess. That was so informative, and I really appreciate that you included those examples. Unless my co-hosts are seeing questions, I don't see any questions.
I also don't have any questions. Nancy?
Nope, no questions yet.
All right, does anyone have any questions?
I was actually in the middle of typing, so I'll just come out and say it. Why were damages removed from like one of the remedies? Or do we know why?
The Supreme Court decided that they should not be available. I believe it was related to another civil rights statute not having emotional distress damages available, but that might not be correct. But essentially, there was a court decision that came out that changed that or limited that, and so that's a fairly new change, and not one that we like, but one that we're stuck with.
And just as a quick follow-up, you said but there's like a a small percentage where it's like in strong intent or something like that. Can you give an example of what that may look like, the intent?
So really we're looking at in most of those cases a purposefulness in taking the negative action against the student. So not something that the school district can say, oh, we didn't understand that that's what we were doing. We didn't realize that that's the impact we were having. It's generally trying to prove that there was a knowledge and an intent in taking that action or depriving the student of an accommodation.
Awesome. Thank you so much.
Could I just ask people to please direct their questions to the chat? One of the reasons we do that is because this is a recorded session, and we want to make sure that there is, no inappropriate disclosures of private information. Alfredo, I see that you have raised your hand with a question. I would encourage you to put that in the chat, and I promise we'll get to it. I am seeing a new one right now. Are schools required to honor a request for an initial evaluation for an IEP in summer months? I actually know the answer to that question, if you don't mind, because it's more IDEA related. But the answer to that question is yes. No matter what time of year you make a referral to a committee on special education, the school district has 60 days to evaluate the student, hold a CSE meeting to determine eligibility, develop an IEP and implement those services. And there is definitely case law and guidance that is clear that school districts do have to conduct evaluations over the summer. So I hope that answers that question. And the only thing I want to add to that is that 60-day time period starts from the date that the parent consents to an evaluation in writing. So if you are making a referral for evaluation for special education services, it's also important that you request, obtain, and sign that consent as soon as possible, because that's what triggers that event. Okay, next question. When parents are making a request for a 504 accommodation plan, should the following be addressed? And if so, how and by whom? First, a parent states that they met with the school counselor and this counselor suggested a 504 plan and provided a physical form with an ADHD diagnosis with no other information. The counselor references that the American School Counselor Association has said on 504 plans that initiating, writing, and managing the 504 process are non-school counseling tasks and inappropriate duties for a school counselor. So Jess, I don't know if you got the meaning from that question. Do you want me to ask?
I'll start. I'm not sure that I do understand the question necessarily. I will say that generally we would not see a school counselor being the person to draft and implement a 504 plan. Certainly, like I said, if a school counselor believes that a student with a disability might benefit from a 504 plan, then we would love to see them suggest that that path to the student and their parent. And typically we see, I didn't mention this in the presentation, I mentioned that 504 plans often look like IEPs. We often see the CSE team also handling 504 plans. They'll sometimes call themselves something different if it's a 504 meeting and not a CSE meeting, but we often see the head of student disability services, the same folks that are part of the CSE team. Those folks are typically part of the 504 team too. And so a school counselor might be part of that team, but we wouldn't necessarily assume that they would be the only person or the primary person implementing a 504 plan for the student.
Related to that, Jess, because I was trying to process it as I was reading it, but I just wondered if a school counselor can make a referral for consideration of a 504 plan.
Yes, so under the IDEA, there are, really explicit provisions about, schools identifying students with disabilities and referring them for special education services. And we can have school districts and school personnel under Section 504 identifying students. But sometimes, I think I mentioned this, it's more difficult if the student's disability is perhaps a medical one that doesn't impact learning or is an invisible disability. So there isn't always the same affirmative obligation, which is why we see parents and students requesting accommodations under 504 in the ADA. But if a school counselor wants to suggest that path to a parent or a student, especially if that student has previously been found to not qualify for services under the IDEA, they might qualify under Section 504. And so they really might benefit from learning about that, especially because not many folks know that that's a path that can be helpful to students with disabilities, because it's just not as common.
All right. The next question, again, we might need some further clarification, but it says, in what case can a student ask for tutoring, elementary or college? Is tutoring a 504 accommodation in your view?
It can be, depending on, and that's going to be probably an answer to a lot of these questions, which I know can be really frustrating, is that it really depends on the circumstances. I think one of my examples talked about tutoring for a student whose disability made her miss a lot of courses. So certainly in those situations, it can be. We were talking primarily not about the higher education level today, but I have in many cases seen access to tutoring services as an accommodation that's provided by disability services at the college level. And so it's definitely that extra help and support is certainly something that can be provided and outlined under a 504 plan.
Okay, that's really helpful. Just a heads up out there that when we're talking about the college level and the need for accommodations, it's really important to recognize that the burden is on the student when they reach the college level. So there isn't, you know, in when a student's in primary school, high school, there isn't the school has an affirmative duty to try to identify students with disabilities and figure out if they need services. That is not true in college, but every college campus has a disability center. And unfortunately, each one has its own process for requesting accommodations. So if you are a student and you're going to college and you feel you may need extra time on tests or tutoring support or whatever it may be, you're going to have to go through the process that disability office requires. It usually is some kind of evidence within the last couple of years, like an evaluation or an IEP, showing the kinds of accommodations you had received at that level, and then the specific things that you're looking for at the college level. Then there's an approval process, and then it's also often the student's burden to make sure that they're sharing those accommodations with their professors. And if there's a problem with compliance, then they're using that disability office to help enforce their rights under a 504 accommodation plan in college. All right. This is another one that's a little, I'm not sure. It looks like if a school hasn't been maybe carrying out a 504 plan or implementing the 504 plan or perhaps an IEP with consistency for a long time, are there cases to support a push on the regular timeline and a requirement to exhaust administrative remedies? Definitely would need more information, don't you think, just to figure out what the
Yeah, I mean,
that
what
would
I can
be?
just say generally is that the 504 and the ADA do not have specific timelines for requirements. And so there are no specific outlined steps that a parent is required to take in order to get to federal court or an administrative complaint. Again, assuming that they don't have to exhaust administrative remedies. So if you're making a 504 or an ADA claim, you're not subject to those timelines and those rules under IDEA. And so there wouldn't be any, you know, timeline that you have to follow there. It would just be reasonable, which again is a broad term and hard to you know, say without the specifics of the situation.
Okay, thank you. Just going in order here, how long does a school have to hold a parent requested CSE meeting after a child is classified? I think we're catching the end of the year blurry right now, Jess. So here's some IEP questions. Typically, there isn't anything prescribed in the regulations on when that has to happen. But it has been interpreted, like the 60 days has been interpreted, the 60 days that's allowed for the initial evaluation. But I think there's often times where there might be a more urgent matter, you know, a change in circumstances for the student or something like that. And you know, schools should be meeting sooner than that. It really depends on, I think, whether there's a significant change in circumstances. But there's
I have a question that came directly to me too, so I'll throw that in now. Can you talk about the determination of eligibility for 504 accommodations and mitigating measures such as medication for ADHD? So what we would be looking at with 504 or ADA accommodations is, can the student, as they are at school, access all aspects of the school day that students without disabilities can access? So just because a student has a medication for ADHD or for any other disability does not prohibit them from having additional accommodations under Section 504. And so again, it's difficult in some of these questions to really give answers without more details, but a student having mitigating measures such as medication would not foreclose the opportunity for them to have accommodations if they need them in order to access things throughout the school day.
Thanks. I'm gonna focus on the 504 ones moving forward, and if we have time at the end, we can move more into the ones that are pretty plainly IDEA. So here's a question from someone. I'm a general pediatrician, and once a child has a diagnosis of ADHD, we usually just write a note with the diagnosis and request appropriate accommodations. Am I supposed to list accommodations requested?
You can. So we'll often, if I was assisting that student that had been diagnosed with ADHD, and a school district, so the student and their parent write a letter to the school district saying, Joey has ADHD, he needs XYZ, and the school district says, I'd like some medical documentation to support that accommodation request. If we supply the note that from the doctor that says Joey has ADHD, needs accommodations, the school district might accept that. We would love it if they did, because we could move the process forward. But the school district might also say that they need more detailed medical documentation, and they would likely be entitled to that depending on the accommodation. So we would want the medical documentation to be more specific if possible, but there are certainly circumstances where the parents or the students, the guardians, they are open to what the school district might suggest for the particular disability and then the situation that we are trying to overcome or put on equal footing. And so it can be difficult for a doctor to write a letter requesting the specific accommodation if the parents and the student don't necessarily have that accommodation in mind yet. And so it's often a back and forth during this discussion process where the student will make the request to the school will ask for documentation, and then maybe the student needs to go back to their doctor and then bring it to the school and maybe needs to go back again. There can be some back and forth. But if there are particular accommodations that you as a practitioner have in mind that you know have worked for your patients in the past, or that the student or their family know that they'd like to request, it's great to see those specifics in the medical documentation right from the start.
Thanks. That was helpful. I'm going to skip one and come back to it, but just related to what you were just talking about. Here's another one. What are the resources to learn about what types of accommodations and services exist that you might want to ask for? Are there certain buzzwords to use to know how to advocate?
So some good examples can typically be found either probably on the Department of Education's websites. They have a lot of publications that talk about example cases and go into specifics on what would or wouldn't be an accommodation. But really, within reasonableness, kind of the sky's the limit on what you're asking for. So think about and you have a conversation with your child's doctor about what would help. And we would, often see doctors who maybe have suggested certain things in the past. Hopefully you can have an open conversation with the school district about what they may have done in the past that might help this student. Talking to other parents of students with this type of disability, or just other individuals that have that disability. Again, it's not necessarily that this disability always equals this accommodation, but we do see trends where the same general types of accommodations can be helpful to people with similar disabilities. But it's tough to give a definitive list because everybody's needs are so individualized.
Yeah, that is so true. Another resource that can be helpful is, especially for, well, just generally, if you even Google ADHD and 504 accommodations or diabetes and 504 accommodations, there's a lot of parent groups or associations that are sort of diagnosis based that may provide a list of things to consider. There's certainly, as Jess said, it's definitely individualized, but I have found that to be a successful way of trying to expand my knowledge of what could be appropriate, because no doubt it is frustrating to know your child needs help, but not sure how to get it. Next question is, if a child cannot go on trips, I think it's field trips, because the school nurse is not available, example, to administer asthma medication that they do not use on a daily basis, only when ill, is that a reason to take action?
So a couple of things there, but my first question would be, is the medication required to be administered by a nurse, or can someone else who's attending the field trip be trained to administer the medication? For example, in New York, there are specific requirements that a nurse, an RN, can only perform some of the diabetic related tasks for students who are dependent on staff for their diabetic related needs. And so in that situation, it would be necessary for an RN to be present at the field trip, but there are other medications where perhaps a teacher or a support staff could be trained to administer the medication if necessary, or but if there is a situation where it is necessary to have nursing staff, we would want the school district to go through absolutely every effort possible to have a substitute nurse and extra, whether they send the school nurse and bring in a substitute for the day or hire a substitute to go on the field trip. We wouldn't want to see that access to medication be the reason that the student can't go on that field trip. And we would generally find that, again, subject to all the details and the specifics of that situation, we would find that to be an accommodation, a reasonable accommodation under the ADA and 504, and we'd want to see that student be able to go on that field trip.
Okay, can a district require an updated diagnosis to maintain, excuse me, a 504 plan, sorry, at the annual review?
It depends on the nature of the disability. If the disability is a permanent one, then updated medical documentation not be required. For example, if a student is paralyzed and they're a wheelchair user, we're not going to require that they prove that or document that every year. If the student is deaf and requires a sign language interpreter, we're not going to require them to prove every year that they didn't miraculously recover their hearing. If it is perhaps an injury that leads to a time of temporary accommodations, then the school district would be able to ask for updated medical documentation. Something I've personally seen is, I was just talking about students with diabetes. It is often the case that as a student with diabetes gets older, more towards middle school, high school, they're able to independently manage their diabetic care throughout the school day. And so that would be reevaluated every year, every couple of years, to see how those accommodations might change as the student's disability and their abilities to manage that disability change as they grow and as they go through the school system.
And just in follow-up, in the situation that you were talking about where they may need to update information in the case of an injury or something like, or aging ability, the ability of someone to manage their own care as they age, is there a prescribed timeline that the parents have to provide that information?
So we don't have specific timelines like we do under the IDEA for many things. It's all within a reasonable timeline. So just like you want the school to respond to your requests within a reasonable amount of time, we want to get that information back to the school district within a reasonable amount of time. And we find that as long as there is an open line of communication, you tell the school district, thanks for requesting this. We reached out to the doctor. They said that they can hopefully have it to us by the end of next week, and keeping each other updated just like if you were to send the request into the school district, it would be really great if they said, we got your request. We're having the 504 committee take a look at it. We should have a response to you next week, the week after, something like that. Can help keep that discussion moving and that timeline moving, but there isn't a specific number of days or anything like that that is required under the law.
Thanks. Couple of questions kind of related to related services. How would you go about getting related services for a child who starts school in the middle of the school year? The child stopped receiving related services in February. I'm not sure.
I'm not sure if that means that the student started a different school or something like that, but you can request reasonable accommodations under the ADA and 504 at any time. Whenever you recognize a need for them, they can be requested. And so you would send that letter, that request that I talked about, and get the ball rolling, and the school would respond to that. And like I said, that can happen at any time.
Another question, which is a great one. Can a child get OT for fine motor skills with a Section 504, or do they need an IEP?
They could get it with a 504. If for some reason they've been found ineligible for the services under the IDEA, then again, it depends on the circumstances why they were found ineligible, and why, if maybe the services aren't related to, maybe they're found ineligible because the OT wouldn't be related to their ability to learn and ability to access their education, but would somehow be related to their ability to access other aspects of the school services. It's, again, tough to know without the specifics, but to just broadly answer, I can't think of anything that is prohibited under the ADA and 504. There is no list of things that says these are not accommodations that you're ever able to receive. And so make the request, and and have the discussion and see kind of what you can land on. Again, the ADA and 504 are really broad laws about disabilities and about giving equal access. And so you're going to find a lot of flexibility there and a lot of room for creativity in finding what services work best for the individual.
So would that also hold true for, let's say, a student who may have some behavior challenges, obtaining an FBA and having a behavior intervention plan in place? Could you do that under the 504 without there being an IEP in place?
Again, it depends on what the actual services that are part of that plan are, but it could be. We don't want to assume that a school meeting their obligations under the IDEA or a student not qualifying for an IEP means that the student doesn't qualify for services under Section 504 or the ADA, or that the school is meeting its ADA and Section 504 responsibilities. So it's worth taking a look at and having the conversation. And again, it always just has to connect back to the student's disability and how that disability may be preventing them from accessing some aspect of the school system that students without that disability get access to.
That is super helpful. If a child's social anxiety is so severe that they're unable to attend school and they do online coursework, but the district requires them to come in for tests, and the student is not willing or able to go into school for tests, is there an accommodation to be had there?
So I would say yes, some of that's going to depend on what the school's reason is for saying that the tests have to happen in person. We don't want that reason to be that all tests for everyone have to happen in person at the school district, because like I said, blanket policies are often not considering folks with disabilities and accommodations. And so we can find those discriminatory under the ADA and Section 504. But on the other end of that, we have to consider fundamental alterations. And so for tests, for example, it could be the integrity of the test and wanting to make sure that the student doesn't have access to notes, information, that students who are taking the test in person wouldn't have access to. But with the information that we have here, perhaps the student could take the test on camera or with multiple cameras or something to ensure that the integrity of the test. I will say that the bar exam and many other very secure exams were administered remotely for several years during the COVID-19 pandemic. So there are certainly ways to administer tests securely remotely. And so again, if the school's reason is just that we don't do tests remotely, then that's not a good enough reason under the ADA and 504, and we'd want to continue that conversation and see what reasons the school has and what we might be able to do to address those concerns.
Thanks for that. Just given the season, that could be related to the New York State regents as well. And, there's remote, there's also creating a separate space for that individual to take a regents exam that may be on school property, but in a one-on-one setting or something like that.
Absolutely. And that's what I mentioned during the presentation as well, that you're entitled to an accommodation, but not necessarily the accommodation that you want. So if there's another accommodation that's effective and balances the need of the school district, again, in this example, maybe for testing integrity and the needs of the student to not be in an environment that invokes their social anxiety, like Julie said, maybe a private testing environment, then perhaps there are other accommodations besides remote testing that might meet the student's needs.
Okay, the rest of the questions that I have here are a little bit more IEP related, okay? Yeah. How does a parent handle a situation for a child with an IEP that was suspended for some type of behavior, and it looks like was not found to be a manifestation of their disability? Child is given tutoring, which takes weeks or months to find, so delays in providing those tutoring. It's frustrating for parents and children as they are losing so much academic instruction. The school seems to be in no hurry to find a tutor, or there don't seem to be any repercussions if tutoring isn't provided. You have thoughts on that?
I don't know. Do you, what?
I do.
Yeah.
I do. And I don't mean to, I mean, you are the 504 goddess, and I hope the rest of the audience doesn't mind me chiming in. I've done special ed law for a while and more on the IEP side. I always defer to Jess for the 504 stuff. There is a requirement to provide tutoring and to provide it promptly. And it really doesn't matter whether the student is a student with a disability or not, but because they're a student with a disability, there's extra protections when a student is suspended. They're essentially in an interim alternative educational setting. IAES is the term for that. And the school district must ensure that the child is receiving a free, appropriate public education while they are out. So receiving educational services as well as related services that might be on that IEP, like counseling, PT, OT, speech. Those are things that have to be provided during that period. And so if they're not being provided, it's really important to keep track of what isn't being provided, with the recognition that it is really hard for school districts to find tutors these days, especially in upstate New York. There's just a shortage of providers generally. And we're seeing a lot of students not getting services that they're supposed to be receiving. And it may be a diligence issue, but it may be that there's just no one out there. So one of the things that you can do is seek compensatory education, because if the student was supposed to be receiving these services, they are entitled to them. That is part of their fate. And so getting compensatory services may be helpful. We can put a link in, but on the Disability Rights New York website, there's a fact sheet there's a toolkit actually on securing compensatory education services. And it says under COVID-19, but all of the legal principles in there still apply. So that's something you may want to look at and then have a discussion. You could also contact State Ed, the Special Education Quality Assurance Unit. That's CEQA. We had a whole presentation on CEQA back in April, if you want to check that out on the YouTube channel. But sometimes the regional associate for your area can help kind of close that gap and make sure that students are getting what they need. Next question is, if the CSE recommends to send a child to an integrated classroom at a different school because the assigned school doesn't have an integrated classroom, and parent doesn't want to transfer the child, but still wants them to receive speech therapy services, can the CSE or the district deny the child's speech therapy services in their homeschool? In other words, sounds like sort of an all or nothing. If you want speech therapy, you have to go to another school.
And that, again, without knowing more, sounds problematic. It sounds like speech services aren't really related to this recommendation for the integrated classroom. And while that does sound like it's probably happening under the IDEA, it sounds a lot also like the retaliation that I was talking about at the end of the presentation, where we're trying to intimidate and coerce the family into taking the steps that the school district wants in order to access all the services they're entitled to. And based on what was provided there, I don't see why speech services wouldn't be able to be provided independent of the other issue or conflict about the broader placement.
Yeah. Thank you. There's also some really good language in a document called that State Ed produced, which is a super helpful advocacy document for everyone, for school folks, for parents, for everybody, called the Guide to Quality IEP Development and Implementation. So that's the Guide Quality IEP Development and Implementation on the State Ed website. And that talks in several places about the requirement of the IDEA, and I think 504 as well, that the district needs to focus on the student's needs and not the convenience, its own convenience in delivering services. And so if the reason for this is that we only have a speech therapist at this particular school, that may run into some issues with under the IDEA, at least because we're really supposed to be in a least restrictive environment, which would be the student's home school, all things being equal. However, I also want to be clear that a school district, and there's a lot of case law on this as well, can decide how it administers its own services. And so if the only school that the inclusion classroom is in another building in the district, they can insist on that. Because that's a classroom, it's a placement, it's a bigger thing. But when we're talking about an individual service, it may be more questionable about how that works. I believe that is all of the questions. I see that Helen has put the Comp Ed toolkit on the website or on the chat, which I appreciate. And also the evaluation, is that out there?
Yes, we have the evaluation, the Comp Ed toolkit, and the NICED guide to quality IEPs.
You are amazing. This is an amazing team. So we really encourage you, as I said in the beginning, to complete that evaluation. It helps us in so many ways, and also be sure to add any topics that you would like to see for the 2025 Lunch and Learn series. I want to especially thank Jessica for providing all of this fantastic information today. It was like so helpful, and again, having the examples was really, I think, helps explain it in real life and gives a good understanding of what these concepts are all about. And so we really appreciate you taking the time and sharing your knowledge. Well, we got one more question though, and we have just 1 minute to answer it. So, how do you appeal after the meeting if you're not satisfied with a 504 decision? I'm going to just stick with 504.
Sure. So this is what I was talking about with your remedies. And so you have to first look at, and this is something you might want to talk to an attorney about, because like I said, it's a confusing determination, whether what you're requesting would require you to go through the IDEA exhaustion process first, the due process hearing and all of that. And if it doesn't, if it does, you go through that process. If it doesn't, then you could take that complaint directly either to federal court and file a lawsuit, or to an administrative agency. And you'd file a complaint of discrimination, explain why you believe that the law was violated, and would ask that the court or the administrative agency remedy that, typically, which would be by ordering the school to provide the accommodation that was requested. But that first determination of whether you need to exhaust or not is going to be a key one, because if you go to court without exhausting when you were supposed to, you're going to end up putting yourself further behind. So like I said, I really recommend talking to an attorney about it, unless it's a really cut and dry thing that you feel really confident about, because often amongst attorneys we'll have long conversations trying to decide if we think it needs to be exhausted or not. So it really is kind of a specialized analysis that I think would really benefit in most situations from a professional opinion.
Terrific. What a great way to conclude. Thanks again, Jess. We appreciate it. And everyone else, have a wonderful summer, and hopefully we'll see you next January.